You're all very welcome here this evening. And for the report, the launch of the report into Compensating Victims of Crime. So, this report forms part of the Law Reform Commission's 5th programme of law reform. The current scheme for compensating victims of crime is over 50 years old, actually older than the Law Reform Commission itself. And it became clear from our consultation, which commenced in 2022, that substantial reform and modernisation was required. On behalf of the Commission, I'd like to thank all of the individuals and the organisations who made submissions, who participated in our survey, who attended meetings and seminars on the topic. We also had regard to the large body of Irish case law about the scheme and the developing European jurisprudence about the Compensation Directive and also about the Victims' Rights Directive. We had the advantage of being able to do a very broad sweep of international best practice, not just the UK and Northern Ireland schemes, but also other European jurisdictions because of the EU angle on this, the Netherlands, France, Bulgaria, all sorts of interesting countries, and also other common law jurisdictions in Australia and in the States. For this, I would like to thank our crack research team, which was headed up by the very dedicated Darren Ansbro. And you will see in the report that many LRC researchers contributed to this since 2022. And I'd like to thank all of them for their interest and their commitment and their unflagging enthusiasm for the topic. I'd also like to thank all the commissioners, most of them are here tonight, for their work in relation to this as well. It's really great to see so many people here this evening. I think that all of that work has resulted in a really good report. It adopts a victim-centred, rights-based approach for the reform of compensation for victims of crime, and it aligns with the EU and Irish law requirements. To tell you about it, I'm going to hand you over to 3 speakers who all have very different experience and bring different perspectives and experiences. And I'll just introduce them before I ask each of them to speak. So first of all, I'm going to ask the President to speak to the report. And obviously, he doesn't really need an introduction, but Mr. Justice Frank Clarke is called to the bar in 1973. And the inner bar.
All lies.
And to the inner bar in 1985, he served in the Bar Council and on the Council of the King's Inns. He was appointed a High Court Judge in 2004 and to the Supreme Court in 2012. And he was Chief Justice from 2017 to 2021. The reason I am telling you all of that was that he was appointed the President of the Law Reform Commission in July 2022, just as this consultation was launched. And his very extensive experience as a lawyer and a judge was invaluable on this project because it touches on so many legal issues, not just Irish law about victims' rights and EU developments, but also tricky issues like how to frame our definitions sensitively yet robustly, how to keep our reforms in line with the law of tort and criminal law, and how to differentiate them at the same time, how to weave in legal concepts like subrogation and double compensation, and how to give teeth to the little used provisions about offender-based compensation. So we even called on his experience on the Civil Legal Aid Review Group from which he chaired and which issued its report last summer. So I'm very glad to invite the President to present the report to you.
Very much, Siobhan, but I start by echoing Siobhan's comments about our wonderful research team headed up by Darren. They went far beyond the call of duty. The last point of clarification that Darren raised with me was late yesterday afternoon when she was clearly still working away with the team on finalising some of the more complex points of detail. And that's just a description of the degree of dedication which the team as a whole brought to this project. And I think I should also recognise Mr. Justice Maurice Collins, who, until his recent finishing of his term, was the commissioner who was charged with principally coordinating this project. I want to just make a couple of general points before then introducing what I see as the principal recommendations of this report. You will see that we have, along with the report, produced a draft bill. That could play a number of roles. I'm sure it'll be of great assistance to the Attorney General and his drafting section if the government decides to go along with our recommendations, though I know they always bring their own angle to the drafts that are produced. But I think there's, and it may speed things up, we'd like to think. But I think there's also another important role that a draft bill plays in a lower form project, because inevitably trying to put legal language, clear, enforceable types of phraseology that will work and will not lead to confusion or difficulty of implementation is in itself a difficult task, but it often throws up problems which we haven't addressed in considering the recommendations in the report. And that was absolutely the case here. There were very many, perhaps knotty or small issues that arose in the context of trying to put an appropriate draft together that led us to have to reconsider certain aspects and deal with points of detail that we perhaps haven't been able to focus on in quite the same way. And I think it's important that the public generally know that that is an important part of the process. It sometimes makes it longer before the Commission is in a position to report, because these issues, when they're thrown up, have to be dealt with. But nonetheless, it makes the project, in my view, a lot more robust. And there are a lot of issues of considerable detail to be found both in the report and in the bill that would be way beyond the scope of an occasion such as this to go into all of them in detail. But I'll just give one example of an issue that took a lot of debate in the Commission over recent weeks, and which, while it perhaps won't affect a very large number of people who might make claims for compensation under the scheme, does affect certain categories of persons. And I suppose the moral of that story is, if you happen to be in the situation where these difficult issues apply to you, then it is very important that the scheme deals properly with your case, even if it doesn't affect the vast majority of claims. We had to put a lot of thought into what happens in cases where the victim of violent crime has died. Perhaps the most straightforward case is where someone dies immediately as the result of the crime. Dealing with compensation there is a concept well known in the courts, in civil cases where, for example, someone might be killed as a result of a car accident or in some other circumstances giving rise to civil liability. But as we thought it through, there are many other variations on the theme. For example, what happens where someone is injured in the course of a violent crime, but dies before their claim has either been brought, or perhaps has been brought but not yet decided, and where their death in case A was as a result of the crime but somewhat late, or in case B was just independent of the crime. And each of those raised difficult and different questions which we had to address. Now, I just quote that as one example, or many other examples that could be given which are equally important to the kind of people who those examples apply to. But getting these things right is, I think, the aim that we had from the beginning, and I'd like to think we've certainly got most of them right. And perhaps one added reason for that level of care and the length of time it sometimes takes to deal with it is we are recommending, as we'll hear in a moment, that the scheme be placed on a statutory footing. And we all know that amending statutes can sometimes be a difficult task. And again, I'm sure the Attorney General could speak to this more than me, but there's a finite amount of parliamentary time. Departments fight over who gets to bring forward what legislation. And therefore, even though a problem may be identified in a piece of existing legislation, it's far from a slam dunk that it's capable of being remedied in early course. And therefore, all the more reason to get it as right as you can at the beginning. Have we got everything right? Who knows? If we look, the proof of the pudding will be in the eating. But I'd like to think we've got an awful lot right. And equally, there may be issues where people can legitimately have different views. There may be aspects of it that not everyone would agree with. But again, I think we've produced a balanced report that has realistic prospect of finding favour with the government and of relatively speedy implementation. With those general observations, I'd like to just highlight what I see, at least, are some of the key recommendations in this report at a big picture level. taking into account, as I've said, that there's an awful lot of detail that there isn't time to go into at this stage. Firstly, there is the point I've already mentioned, that it is our recommendation that the scheme be placed on a statutory basis. As I'm sure almost everyone in this room knows, the current scheme is purely an administrative scheme. There is no statute underlining it. It gets the funding it gets. It's organised through the Department of Justice. Of course, the decision makers are independent, but we believe a statutory scheme establishing an independent statutory body is the way forward in the area of the compensation of victims of crime. And I know there is some litigation in being where that very case has been made. We don't express any view about whether there was already an obligation on the state to have a statutory scheme. We're suggesting that as a matter of good practice, it is the best way to do it. Secondly, as I've just mentioned, we are recommending that that statutory scheme create an independent statutory body who would be charged with delivering compensation for victims of crime, violent crime, in accordance with the Act. And we are suggesting that that statutory body have 3 layers of tiers. And I want to say just a little about each of them, but perhaps most importantly, the first tier, which is an assistive tier. One of the things I think we heard loud and clear from those representing victims of crime was that they often find it difficult to navigate through the existing system. And it's difficult to produce all of the documentation required to satisfy those who make the decisions. That can cause delay, that can cause additional trauma for people who are going through a difficult situation anyway, having been the victim of a violent crime. And I suppose to some extent have to revisit this in any event to make their application. But we feel that the burden placed upon victims making applications should be made as light as can practically be done, consistent with having a workable and feasible scheme. And therefore, the job of our recommended assistive tier will be to help victims to ensure that they put in their case in the way that's most favourable to them. That ensures that all the necessary documentation that they need to support their claim can be made available. There's provision that with the permission of the victim, which of course is their choice, the assistive tier can themselves seek out the documents if they need to get a report from an employer, for example, the amount of wages lost. As I come to, we're recommending, as would be necessary in any event now, to comply with European Union law, that there will be compensation for pain and suffering, as it were, for injuries suffered. Well, there will need to be some kind of medical support for that. And again, the assistive tier will be able to help in identifying what kind of documentation you would need from medical professionals to support them. But all of that can be, to the extent that any victim wishes, be handed over in our recommendation to the assistive tier. So that when the case goes up one step to what we call the adjudicative tier, it's ready to be properly dealt with. And at least in the vast majority of cases, shouldn't require any further information to have to be given to that tier, which should speed things on. I'll come back to possibility that we might need on top of that assistance, some legal representation at a later stage. A second major recommendation is that everything possible should be done to ensure that compensation is paid as quickly as possible. I think, again, one of the legitimate concerns we have heard very strongly from victims is that a process that takes a long time, but often is adjourned pending court proceedings, which leads to it taking a long time before people get the compensation to which they're entitled, is far from ideal. And therefore, we're suggesting that the default position, if you like, should be that the case should be dealt with as it is ready. So as soon as someone gets their documentation together with the help of the assistive tier, it should go before an adjudicator, and the adjudicator should be able to make a decision. There obviously may be some cases where there will be a risk to the administration of justice in the form of either civil or criminal cases. And there therefore will have to be a possibility that cases may have to be delayed for both reasons. but it is a strong recommendation of the Commission that that should be the exception rather than that the default position should be early compensation. We're also recommending that there be an appeal process so that persons who are dissatisfied with the decision of an adjudicator will have a right to appeal to a 3-person panel against that decision. And we believe that gives a further layer of robustness to the system. And also, hopefully, there won't be complex legal issues in many cases, but where there are, we're recommending that there be provision for the matter to be referred on the High Court to resolve any difficult legal issues. And that leads to the question of whether there ought to be some form of legal support, lawyer support, if you like, in the system. I think the Commission is very much of the view that as much as possible of the funding that the state is prepared to make available should go into the pockets of victims. It should not, I suppose it's easier for someone who is a lawyer to say this, but it should not become a lawyer fest, where the principal beneficiaries are lawyers. And whatever funding the Minister for Justice is able to extract from the Minister of Public Expenditure and Reform is going to be finite and nowhere. And therefore it should be geared towards the people who are meant to get it. But we do recognise that there may be cases where, for one of 2 types of reasons, there may be a need to have something a bit more than assistant here in the form of legal advice or legal representation. Sometimes it may be the complexity of the case. There may be difficult legal issues in certain cases, though we would like to think not too many. And there may be cases where the vulnerability of the individual making the application means that they would not find it easy to be able to present their case properly without some form of legal representation. So in either of those cases, the decision maker in the statutory body will have an entitlement to make an award of costs where they're satisfied that a lawyer was necessary to allow the proper presentation. And we do realise that in some cases, perhaps even a narrower group, the victim would be unable to secure a lawyer without some guarantee that that lawyer was paid an appropriate amount to court fees. And there is therefore provision that the statutory body can make a sort of pre-clearance of an entitlement to costs at the beginning in cases where the statutory body is persuaded that within that clearance, the person would not be able to gain proper access to the system. So if you're well off and you don't need a lawyer, you can still have one, but you can pay for a lawyer yourself. If you're well off, when it was a complex case, you can pay for your own lawyer, but you may get some back from the tribunal. But if you're not in a position to be able to afford a lawyer in the first place, and you need one, then the system that we're recommending will provide for a mechanism whereby that will change. I have mentioned that the decision of the European Court of Justice has made it clear that the system has now to include compensation for injuries, as well as what the current system provides, which is recompense for what one might loosely call financial loss, whether that's in the form of lost wages, medical expenses, or the like. And it behoves the judge or a former judge of a national court to be critical of the Court of Justice in general terms, but it is not entirely unusual that the judgments of the Court of Justice are cryptic in their nature and leave open room for discussion as to what precisely was meant. In fairness to them, sometimes that's because exactly how it will work in 27 different legal systems is perhaps complex and they don't want to create unintended consequences. But the judgment in the case I'm referring to is such that it leaves certainly some doubt about what the court actually meant when it said that the compensation system for victims of crime should have regard to the system for compensation of injuries generally in a country. Who knows what that means? And we have therefore decided to leave that aspect of our recommendations flexible so that the minister can provide scales of potential compensation, and they can would not be hardwired into the legislation, so they could be changed, particularly if there are further developments either in the courts in Ireland or in the courts. Finally, there are a number of measures which we feel are necessary to make the system acceptable but fair. There are provisions for either the reduction of compensation or its total exclusion in cases where the person perhaps contributed to or was the main instigator of the incident that gives rise to the injuries. We also believe that while the state has a clear obligation to compensate victims of crime, the perpetrators of the crime should be the first port of call where that's practical. And there is the current system, which is not very widely used in many courts, whereby a court on convicting a person of a violent crime can order compensation. We've made some recommendations in that regard, and we've also made further recommendations to ensure that there's no double compensation, so that where it is possible, in some cases, for the perpetrator to bear the burden of compensating the victim in a way that doesn't cause the victim any further traumatization than the crime itself caused, that should be done. We believe that creates a fair balance and makes it easier to persuade government that this is something that additional funds need to be provided. So my ultimate hope is that the government, and we're hopeful the Minister for Justice will be here later, so if you want to buttonhole him and tell him that you very much think he should get on with the job, we hope that the Minister will be able to persuade the government to accept all of the report, most of it. We hope that the fact that we have a draft bill will expedite the process from policy decision to go ahead to there being finalised legislation. And of course, inevitably, if our main recommendation of a statutory body provided for under statute is accepted, we accept there will be some further time before that can set up and be up and running. But at the same time, it's taking a long time to get here. We hope that the next part of the process will not be so long and that there will be a proper statutory body providing victim-centred compensation to victims of violent crime up and running within a relatively short period of time. Thanks very much.
President, for hitting on so many of the main points in such a short period of time. And I'm sorry for having such a short period of time, but it is a topic we could talk about for a lot longer because it is a very interesting topic. To introduce our second speaker is Dr. Liam O'Driscoll, who's an assistant lecturer in law in TU Shannon in County Limerick. And just last year, 2025, Dr. O'Driscoll finished his PhD, which was funded by Research Ireland. And it was in DCU, and it was about state compensation schemes for victims of crime. And as part of his PhD, he interviewed many victims of crime and lawyers, victim support professionals, and former decision makers from the Criminal Injury Compensation Tribunal, some of whom are here today. And his research on the topic has been published nationally and internationally and informed our thinking in the Commission as well. And we're very grateful to him for coming today to give his take on our report.
So usually when I'm talking to my students, I usually talk off the cuff. So but today I said I better write some remarks down in case I get a bit lost. So I'll be referring to some notes here. So thanks very much for the invitation to speak this evening on the launch of this really important report. I would like, before jumping into the report, I would like to just start by commending all the victim survivors and their families who've campaigned tirelessly for years to get us to this point by highlighting the systemic issues present in the current compensation scheme. In any law reform process, we must always remember that those with lived experience possess essential expertise which must be heard and respected. There's much work left to do to ensure proper reform is thought about, but I hope the publication of this report is a positive milestone for all those campaigning for better treatment and recognition of victims in the criminal justice system. In particular, I would like to commend Ruth for her extraordinary advocacy on this issue over the course of the last few years. I truly believe that we would not be here today discussing reform of this scale if it wasn't for Ruth's work on this issue. So thanks very much, Ruth. And I would like to also commend the Commission for all the work they've done in completing this important report. The issues related to victim compensation are complex, and I would like to thank the President, Commissioners and the research team, and indeed the wider former Commission team for their dedication and commitment in putting together and agreeing to these recommendations. In my remarks, I wish to speak about some of the proposals put forward by the Commission. First, however, I just want to offer some reflections on two questions which we should all perhaps reflect on. So I'm just going to put on my academic theoretical hat just for a moment, if that's okay. So the first question relates to how does a person or group of individuals acquire and maintain victimhood status, and in what ways does the law and society more generally restrict protections and entitlements to certain types of individuals based on economic, social and cultural factors? And two, individuals who have experienced trauma face significant barriers in engaging with officialdom, especially when there are multiple different administrative processes to deal with and relationships to maintain, from police and prosecution services to medical, social and other supports. How does the law account for these consequences of victimization, especially such trauma, which causes many victims to avoid people, places and things associated with or related to the crime itself and the wider justice system? I'm glad that in different ways, this report addresses aspects of these questions. It accounts in part for the reality that many victims struggle for very, very legitimate reasons to report their victimization to police. The proposals call for increased support and legal assistance for victims who struggle to navigate what is a complicated compensation process. Indeed, the report puts in place safeguards to ensure adverse decisions, which do not go in favour of a particular victim, are properly verified where necessary. The Commission are to be commended in their attempts to address these broader issues within the confines of what is a complex area. While huge progress has been made in respect of victims' rights in recent years, further difficult conversations are needed to ensure that every victim at every point in the justice system is treated in a manner where their rights are practically respected. The launch of this report is perhaps an opportunity to reflect on what is needed, not just in the compensation space, but more broadly in the justice system as a whole, for every victim, regardless of the context in which the particular violence takes place. In this regard, we must be persistent and challenge discriminatory cultural attitudes about certain types of victim. We must ensure that every victim is supported to seek the justice they require for themselves. We must ensure that political responses to victimization are based on protecting the rights of everyone who is harmed, not just those who society at a particular point deems deserving of support and recognition. So turning to the specific contents of the report itself, from my preliminary examination of the recommendations, it is clear that the Commission has given this issue considered thought and brought a lot of innovation in terms of the specific legal mechanisms needed to improve the compensation scheme. If implemented by government and given proper backing in terms of financial and staffing resources, the recommendations have the potential to bring about a victim-centred, rights-based and trauma-informed scheme. To date, and I suppose from the scheme's establishment in 1974, there's been huge challenges for victims navigating the process. The process as a whole has been highly re-traumatizing. There has been unfair eligibility rules in place. Victims have received very little support in navigating the system. And overall, there was very little knowledge of this scheme itself. So in that regard, many victims likely have missed out on even knowing about the scheme, never mind even getting the opportunity to apply for it. I would say the most important recommendation, and the President has spoken to this about this already, is the proposal to establish a specific statutory body to administer the scheme. Whatever rules are in place in relation to the type of compensation and the eligibility criteria and the like, having a specific statutory body will allow the proper organisational culture to be developed to deliver effective and respectful access to compensation for all victims of violent crime. I like the Commission's proposals in respect of how this statutory body is to operate. The information and assistance here will assist in ensuring that victims receive adequate support throughout the compensation process. There will be greater obligations on the statutory body to assist victims, especially victims who struggle to engage with the body due to the trauma inflicted on them as a result of the crime. The ability of a victim to request an oral hearing in respect of both the assessment and adjudicative tier and the appeals tier will ensure that victims, if the victim so wishes and the body agrees, can actually meet the individuals tasked with deciding their claim. Paid legal assistance is also proposed by the Commission in both complex cases and with the victims in need of a lawyer. Establishing such a scheme is essential in light of Ireland's EU law obligations in respect of state compensation and victims' rights generally, which the Commission has analysed and incorporated into its various proposals. Other important recommendations include clarifying what is meant by a victim and what victims and what criminal injuries qualify for compensation, extending the applicable time limit within the scheme from 3 months to 2 years, with scope for this 2-year period to be extended, and setting out specific guidance in respect of compensation for pain and suffering. Additionally, the Commission have proposed detailed recommendations in so-called unmeritorious cases where the victim's past conduct disqualifies them from accessing compensation. Here, safeguards have been put forward by the Commission to ensure that victims are only excluded in very occasional cases where the interests of justice so require, and only after a thorough assessment by senior decision makers within the statutory body. Importantly, it is proposed that these restrictive eligibility rules around contributing conduct do not generally apply to victims of domestic and sexual violence. And I suppose, you know, in terms of digesting the report, that's quite a big recommendation, which I think I've set that out correctly there, but it certainly requires more thought. But when I saw that one in terms of the recommendations, it's something that we need to get right, so that you know, a particular cohort of victims don't have those rules applied to them in a way that would be unfair. Overall, I look forward to further digesting the details of the proposals now that the report has been published. The report is robust and contains important suggestions which I really hope will be taken up by government. It would be remiss of me not to say, however, at this point, that there are areas where I would probably have liked the Commission to go further. And indeed, there are issues which I think in time, once we get to the next steps, the government can perhaps think about a little differently, maybe. Today is perhaps not the place to go into this in detail, but further reflection is needed perhaps in certain areas in respect of homicide, the proposed time limit, the retrospective abolition of the same roof rule, and various other criteria that are within the scheme as well. But that's perhaps for another day. I look forward to reflecting ultimately on the contents of the report and working with victims, the Department of Justice, and members of the Oireachtas in addressing these issues going forward. I suppose just to sort of bring my own remarks to a conclusion, in thinking about the next steps, there are a number of priorities which we should keep in mind. In light of the Blanco judgment, so from the Court of Justice of the European Union, there is an urgency to implement these recommendations as soon as possible. This is so that victims currently in the system have some clarity about how their claims will be handled. That's really important. The second is that ultimately, since the scheme's establishment in 1974, inadequate government funding has directly brought about the various problems that have plagued the scheme. At one point, and this is information that I found in the National Archives, at one point there was a decision taken at Cabinet in the 1980s to actually fully abolish the scheme. And then later, with all the changes in government taking place in the 1980s, a later iteration of the government decided to retain the scheme, but then remove provision for compensation in respect of pain and suffering. So I suppose it's essential that the statutory body which is established on foot of this report is properly funded and resourced, and has the funding stream which protects the body insofar as possible from political considerations. So third, and this speaks not just to the issue of victim compensation, I think, it goes beyond the report and speaks in relation to victims' rights issues more broadly. We must develop proper and effective monitoring mechanisms in the criminal justice sector. A victims commissioner or ombudsperson ought to be established so that criminal justice agencies, including the statutory body proposed by the Commission, live up to their aims. Separately then, and this just speaks maybe more broadly around the role of compensation then, I suppose we often have negative tropes associated with financial compensation and money payments. Whilst of course compensation and money cannot return the victim to their former position, we must always seek to ensure access for compensation for every victim. Compensation serves important functions for victims. It acknowledges harm and assists victims in managing the consequences flowing from criminal victimization. Importantly, however, beyond this report, we must continue to reflect on what victims need beyond compensation. Ireland's health and social care systems leave a lot to be desired, and much work is needed to ensure that victims can properly access such state services. Importantly, all we do in this space must be done in a way that eliminates barriers and empowers victims. I do believe that this report is a really, really important step in that direction. So to conclude my remarks, once again, I commend the Commission on the report, and I congratulate the team, and I look forward to diving into the proposals in more detail and in relation to next steps as well. So thanks very much.
Last but definitely not least, I'd like to introduce to you Ruth Maxwell. So Ruth is a survivor of violent crime who has personally gone through the criminal injury compensation tribunal process, and she's been engaged in seeking reform of the process for almost 9 years. She contributed to the Law Reform Commission's consultation paper for this report, and she authored independent recommendations for the CICT reform, drawing on her own lived experience and her work supporting other victims to advocate for a fair, timely and trauma-informed system. And that's what she told me I could say about her. But I would like to add that Ruth is an advocate and a campaigner extraordinaire, and she helped us to really understand this process and how it affects people. And I'd like to thank you for that, Ruth, because her contribution to our report really helped us, and I think that she'll bring a unique perspective to the discussion today.
The last time I was in this room was 2019, sitting with the Retired Commission Byrne after addressing the Law Reform Commission conference in the programme. And here I am so many years later. Yeah, so coming to where it's meant to be. So it's quite surreal, but it's like I'm two people. I'm victim survivor, and then I'm the other side that's educating myself on it and try to do my best to get everyone to listen, and everyone has listened, and thank you for the great work that you've done. It's taken so long to get here, but we're just there. So I guess I'll start. So I'm speaking here as a victim, as someone who supports other victims through this process, and as someone who has been actively engaged in reform at both national and European level. I developed and submitted independent recommendations on this scheme, and I have represented Ireland at EU level on victim compensation, including through Victim Support Europe and its Victims Advocate platform, while also working as a consultant supporting victims through frontline services such as the Sexual Violence Centre in Cork. I want to start by acknowledging that there are strong and welcoming developments in this report before I discuss my own experience. So, most important thing is putting the scheme on the statutory footing. It's a significant step forward. But the statutory body implementing the statutory, I can't pronounce the word, I've never been able to, so apologies. The scheme must have regard to a set of guiding principles which are based on what might be described as the number one principle, namely that the scheme must vindicate the rights of victims of crime or violence to fair and appropriate compensation. And the principle is also backed up by those supplemental sub-principles, which are that the scheme must provide an appropriate contribution towards compensating victims for the harm they have suffered as determined in accordance with the compensation scheme, to ensure that all victims are treated with dignity and respect, aim to prevent secondary victimisation by providing appropriate and trauma-informed support for victims throughout the compensation process. In many cases, they simply cannot. Oh, sorry, that's the wrong page. And ensure the compensation scheme is accessible to victims of crimes of violence without discrimination, compensate victims without undue delay. Secondly, the recognition of a rights-based victim-centred approach is important. Also, the inclusion of compensation for psychological harm and not requiring a criminal conviction or meaningful improvements. The three-tier administrative application may create more efficiency. The first tier is crucial. as for victims, that the first interaction they have while they were still in trauma, and that can be delivered in person or remotely if chosen. And I do know that is in place already, that you can actually ask whether you can do it in person, but in my case, that was not available at the time. Everything was by email, or in very rare cases, phone calls. And the broader definition of victims is also very welcome. So these are all real and positive changes. But then going back into the victim side of things, the issue is not what the scheme says that it will do, it's what victims will actually experience when they're trying to use it. And the people that I support are not straightforward cases. They're traumatized, many are dealing with ongoing abuse, many struggle to engage consistently. And also I work with bereaved families, families who have lost loved ones to violent crime, and who are then expected to navigate a complex and intrusive application while grieving. I actually lost my page. So in many cases, they simply cannot complete the application because they haven't the heart to put the value of €35,000 on their husband's lives. This is a common pattern I see in not isolated cases. So this is not just about access in theory, it's about whether people in these circumstances can realistically engage with the system at all. So creating a three-tier structural system gives a pathway of clarity, with the first assistive one being the crucial one again. And if that first stage doesn't relieve the massive burden of evidence gathering for applicants, then the scheme will run risk again of not being fit for purpose or victim-centred. Most victims and bereaved families do not come to this process with a clean set of documents and evidence ready to go. In domestic and sexual violence cases, victims often don't report immediately, don't have medical documentation, and have fragmented or incomplete evidence. So you say a conviction is not required, but in reality, victims still need to prove their case, and that means gathering evidence many cannot access. If the system still depends on the victim knowing what documents are needed, knowing where to get them, and having the capacity to follow that through, then the burden hasn't been removed. It's just been renamed. So I created a detailed guidance for victims applying to the scheme, because without it, many simply cannot navigate the process. That guidance includes checklists, templates, and step-by-step support, just to help victims gather documents and complete an application. The fact that that is necessary shows that the current system is not accessible in practice. So I also want to say this clearly. I went through the process myself, so I see where it fails. It's very hard to talk about it because the level of trauma from that, it's going to stay with me for the rest of my life. It's the one part that sometimes I just try to avoid discussing because I had sat just crying for 4.5 years. It's a rabbit hole that I keep talking about, that you're gathering documents, then they say, no, we're going to gather documents. There is no clear communication of joined up processes to make it an efficient, a compassionate, and you're retaining your dignity within all of that. None of that was there. It was hostile, it's contemptuous, it was just constantly creating obstructional tactics. And then, Frank, when you were talking about now that there will be added pain and suffering and having to get a report for that, I would presume is what I would have had to do at the end of my own case was another medical report and also a psychiatric report to prove that this had affected me mentally. And each of those reports were in the region of €4,000. And that was the final hurdle, that if you weren't able to get past that one, we're done. And of course, I'd lost everything, my job, the works, I had nothing, absolutely nothing. And then a mediation team was set up with the Department of Justice because I refused to engage any longer because I just couldn't be treated like that anymore because of the injuries I had sustained. There were 5 women who were viciously attacked. Like, to even try and process all of that while going through that was just, I still can't even imagine how I did that. And then continued to start fighting. So at the mediation, I had a friend with me who actually stepped up and said, like, these particular reports, and you will need to pay for them. So the tribunal actually paid for those reports. But it took nearly 2 years for those reports because I was legally representing myself. And these particular reports were only dealt with through solicitors. So it took me, I think, 8 or 9 months to convince these different hospitals and stuff to actually give me these reports because I was now legally representing myself and I got them. So in the area of compensation, the introduction of general compensation for harm, including pain and suffering, is a positive development, but I am aware of that side of it, the whole financial side. So the report proposes 4 categories of harm: minor, moderate, serious and severe, and suggests that the statutory body may have regard to the personal injury guidelines made under the Judicial Council Act 2019 and assessing those categories. However, the report does not indicate what the actual payment levels will be for those categories. It does not state that awards will match the levels set out in those guidelines. So in reality, the structure is being proposed now, but the value of compensation is being left to be decided later, and that creates uncertainty for victims. If the scheme is intended to vindicate victims' rights, then there needs to be clarity about what those rights are worth in practice. So I would ask what level of compensation, can't pronounce that word, is for each category. And can there be early indication from the Minister for Justice of the level of awards being considered? And I also have a concern about the proposed public interest discretion. This creates a situation where a victim can meet all the criteria and still be refused compensation on a vague and undefined basis. So I would ask, how will this discretion be clearly determined and limited in practice? And how will you ensure it is not applied in a way that unfairly affects victims, particularly those with complex circumstances? And now I want to talk about the current scheme with my clients. And to me, it's really serious. The current scheme is effectively paused for many applicants without prior notice or any communication after the rendering of judgment, which was in October for my clients when they heard nothing onwards. And I'm working directly with victims of domestic and sexual violence who have already submitted applications and are now left waiting for long periods with no clarity on when their cases will progress. The tribunal has been awaiting guidance from the Department of Justice since last October. And for those victims, it's not just an administrative delay. They've already incurred medical and counselling costs, lost incomes, and are trying to stabilise their lives after trauma. And they are relying on this process to recoup their costs. The pause is leaving them in financial uncertainty and prolonging their distress. In many cases, it is adding an additional layer of pressure at a time when they are already vulnerable. For victims, domestic and sexual violence, these delays are having a real impact. So I would ask, when can applicants expect the current scheme to begin progressing again? And what specific measures will be put in place to ensure that victims, particularly those in vulnerable situations, are not left waiting indefinitely during this transition? Because if this system was working as it was intended for victims, we wouldn't be sitting here today discussing this reform. And the fact that we are here reflects the gap between how the system appears to function and how it actually is experienced in practice. The report is a clear improvement on the current scheme, but if it is truly to be truly trauma-informed and victim-centred, it must go further how it operates in practice. Because right now, victims are still expected to gather evidence while traumatized, justify delays, and navigate a complex system without guaranteed active support. And I spent 10 years advocating for reform of this system, not just as a victim, but then in a professional and policy capacity. And this reform has to work, and not just in principle, but in practice. And before I conclude, I want to thank everyone here today and the Commission for all the amazing work they've done and the dedication for all these years to bring this to where it is today. And I would also, from the bottom of my heart, have to thank the retired Commissioner Raymond Byrne, John Byrne, Jim O'Callaghan, he's not here yet, Nolan Blackwell, and Mary Crilly, for without her unwavering support, commitment and belief in me, I wouldn't be here today. So thank you.
Very informative perspective. I don't think anybody can really follow that. We're not going to try and follow that. We're not going to invite questions now, but mainly because we're all pretty exhausted. I'm very grateful to the speakers because they actually got very late copies of the almost final report under an embargo just on Friday, and so they have put together their contributions today very short notice, and everybody's pretty wrecked because we have worked to the wire on this one, but we'd be happy to engage by email. There's an email address connected to the report, and we'll answer any questions that we can in that way. Some of Ruth's questions we can't answer, they're matters for the government, particularly the financial ones, and they're matters for the government. Oh, I will. I'd just like to say thank you again, and to offer you all just a glass of wine before and some opportunity for conversation and before you leave. Thank you very much, everybody.